Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we explore the world of innovation, creativity, and intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from inventors, entrepreneurs, and experts in the field. This is a third episode this week where we're talking about the question of, can you purchase competitors' trademark terms as keywords for ads to trigger ads to show up in search engines? Now, before we get started, I want to make it clear that while I'm an attorney, the information I provide on this podcast is for educational and informational purposes only. The information I provide on this podcast is for educational and informational purposes only. I'm not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. All right, with that disclaimer out of the way, let's dive into AdWords and what happens. I'm going to go ahead and cover a case. Actually, it's a set of cases. This is a company called WhenU, WhenU.com. And they were sued by many companies in multiple courts, and they won in these battles. They technically did it right, but they're not in business anymore. My guess is defending all these lawsuits probably put them under. That's just a guess. I didn't search their company history and why they went out of business. But one of the cases is 1-800-CONTACTS Inc. versus WhenU.com. And it was from the Second Court of Appeals in 2005. It's a New York-based case. And this case has been cited by over 100 other court cases. What it said has been repeated over and over. Just because it's been repeated over and over doesn't mean it's the current law. And we're going to get to that of why you might not want to follow this case unless you are very careful about the facts of the case and what happened. What happened was WhenU had an advertising system. It was a pop-up advertisement. People would download it. They would be asked, do you want to download this, when they were downloading other often free things that they download. Somebody will offer a free program and there'll be a little box that they check saying, yeah, download this other program too. This is the program. I discussed it a little bit in last episode where they would have ads pop up by reading what you're searching. So it would be gathering the data from your search, what was showing up, where you were going on the internet, and it would determine the category of what it is you were searching for. They would have advertisers that were lined up in that category, and they would show one of those advertisers. They'd rotate through them and be a random nature of which one was showing up. The keywords that were internally used to trigger that included trademark terms, including 1-800-CONTACTS. They were also sued by U-Haul and Wells Fargo and others. There's a bunch of people that sued them. Some of them, multiple cases were combined together. Specifically the 1-800-CONTACTS case, because that one went up to an appeals court. That's the one that gets cited a whole bunch. They didn't advertise saying, if somebody searches for this keyword, we're going to pop up this ad. It's some of the specific things that really become clear with this case, especially when it's discussed later by this Second Circuit Appeals Court later in another case that comes up more recently than this one. The question is, how are they presenting what they're presenting? And are consumers likely to be confused? This was a separate pop-up window that clearly indicated this was WhenU's advertising. People had opted in and said, yes, you can have this pop-up show up when I'm searching for things and show me advertisements, or it would be in a sidebar that it was clearly separate. It was really clear. This is an ad over here. This is not your search results. And a lot of these cases, like the other ones we've been talking about, is they were at an early stage in the case when they're trying to make a quick decision. And in this case, the question was preliminary injunction. When you file a lawsuit and you want to stop somebody from doing what they're doing, which is different than just, hey, you owe me money. It's that you are continuously harming me and I need an order for that to be stopped. So and that was a preliminary injunction stage. Here again, they said, they used this term as I discussed in a previous episode, that Wells Fargo trademark, that the inclusion of Wells Fargo's trademarks was not use under the trademark laws called the Lanham Act, and that it didn't interfere with Wells Fargo at all. So that was the reasoning they used. But really, the reasoning that should have been used is they were not confusing anybody. People knew that they were viewing advertisements that were not Wells Fargo advertisements. U-Haul was very similar, and they said that it was a pure machine linking function that was not, quote, use under the trademark or under the Lanham Act. So they use that use language again. There's another court that discussed this whole issue. It was from 2009. Google was sued by Rescue.com. It was an IT service company, and they were suing Google for using Rescue.com's trademark in selling AdWords. Based on all these other cases of it's not trademark use, they're focusing on this use question rather than are consumers likely to be confused. So the trial court dismissed it and said, you know what, 12b6, you didn't state a claim that can be granted, that you can't recover here based on what Google did and is doing. It was dismissed by the trial court, and it's based on that 1-800-CONTACTS case. Once again, it's the same court, the Second Circuit, 4 years later. They said the district court got it wrong. There were some major differences between what WinU was doing and what Google was doing. The major difference is that WinU was making it very clear that they were displaying advertisements. When the lawsuit against Google, it was still a question of fact, whether Google was clearly indicating that they were displaying advertisements and not organic search results. So those who have used Google, which is probably everybody that's found this podcast or listening to this on the radio, it was clearly indicating when you use Google, they put a whole bunch of search results, and they've changed it over the years exactly how they identify it. Sometimes they've put the little word ads next to the ones that are ads. Other times they've put the word sponsored next to those. They're always fairly small. I think sometimes they've put them in a box, but it's more clearly separate that these are the advertisements. These aren't your search results. You go to Google to get relevant search results. And when ads pop up, the question is, are the consumers going to be confused thinking those results that are ads are relevant search results? And that was a question that they said isn't a matter of law. We have to figure out the facts of this case before we can tell whether or not that is trademark infringement. The trial court dismissed the Google case early on at an early stage because they thought that selling keywords could not be considered trademark infringement as long as the trademark was not displayed to the end user. But the appeals court said that it's possible what Google is doing is trademark infringement. Now, compared to the WinU system, they sold categories like a phone book rather than selling specific keywords. Google encourages people to buy trademark terms. They suggest what keywords to use. Sometimes those suggestions include trademark terms. For instance, someone searching for airline tickets is likely to type the words hotels in New York in a search engine, or look for articles about the cheapest room in Manhattan. So they had the ability to recognize this behavior and serve an ad for relevant travel partners such as Priceline. The relevance worked at the time. My guess is people just really hate pop-ups, and their model also failed, as well as all these lawsuits for WinU, why they're not around anymore after 2012. So WinU is the facts were very different from what Google is doing. It's very risky to say, oh, this court said this without looking at the very specific facts of that case. In trademark law, because it's fact specific, it's very hard to say unless you are really clear that what you're doing is just like another case. And an attorney can't clearly differentiate between that case and your case. Google, on the other hand, the allegation against Google was that they were displaying ads without clearly telling the consumer using their search engine that they were viewing ads. And coming back to how this case came to the appeals court was it had been dismissed by the trial court saying, even if you assume everything that they're claiming in their complaint, RescueCom was a company and they were suing Google. If everything that RescueCom said was true, could they succeed if they could prove it all was true? And the court said, yes, if they could, because they gave specifics. They didn't just say people are confused. They explained enough detail that the reason people were likely to be confused was because their search engine did not clearly indicate that people were viewing ads, and that the consumer would believe that the top result was the most relevant result because it was at the top. That is a question of fact. Now, that fact wasn't determined in the case. The question was, could this case go forward if RescueCom could prove, if they substantiated that and brought enough facts to the table to show that's what happens, that a substantial number of consumers, when they used Google's website and put in RescueCom brand name into a search engine, and would they think the top results were highly relevant to RescueCom itself, and therefore they would think that those are sponsored or affiliated with RescueCom. And that's why it's still a question of law. Or not. When a case gets dismissed early on, it's usually because the law itself determines that's the case. Now, when you're within the law and it's a question of fact, who wins, you have to go to trial to figure that out. That's what you want to avoid. That's why it is still risky to use a keyword of a competitor